Thank you all for coming this morning and for being open to learn about probate, how to avoid it if we can. I mean, most of us want to control our own lives, right? Who does not? Who in here does not want to be in control of their lives? Or their or what about and your property? So a lot of times as a real estate agent that specializes with seniors, I've heard again and again that, you know, they want to be in control and they want to leave a legacy and they don't want to be a burden to their families. So I don't think they mean to just be a burden anyway because they've left a mess after they, you know, when their bodies have gone, when they're not here anymore. But one thing really touched me a couple of years ago. One of our receptionists lost her dad early. He was in his 60s. And she says, if my dad knew what I was going through, he'd want to die again. You know, so it's just, could be very tumultuous to have to do things. And there's a way to, if we're prepared and we know about it, then we'll know what not to do or how to make things different. So that's what Seasoned Conversations is all about. Educating, equipping, and empowering so that you do have control now and after. We're going to have a broad overview on what probate is, the purpose for it, when probate is necessary, when it's not, some of the common challenges pertaining to probate and how to avoid them, how to protect real property from requiring probate, commonly held myths and misconceptions, responsibility of executors and costs associated with probate. So, how many of you think any of that you have people that could use this information? Right? So, please share. Every month we give valuable information on different topics, and there are things that people don't know. They don't know, they don't know. So it's not 1 hour of your time. I think it would be well worth it. And that's our passion with Seasoned Conversations. It is a nonprofit, so donations are welcome. All right. We're going to start. So listen with 2 ears. One if you're a property owner, and one if you might end up being an executor of your family's estate. Okay? So the 2 panelists we have today are Teresa Walker. I want to rename her sometimes. I have so many T's. I want to give thanks to the Tamara and Tana, which are Evie Holiday Companies. You know, that's one of our sponsors. We're with the Evie Companies. We are actually Dave Perry Miller, which is an Evie Holiday Company. I want to thank Sherry for being here today. She's my I don't know what to say. We've known each other. We're leadership people, and I depend on her when I'm out of town for real estate. She's great. I want to thank the Senior Blue Book, Dallas Supreme Relocations. That's the company that trustees really could use in terms of getting all that stuff done that needs to be done that families just don't have the time to do. What else? Well, Seniors Blue Book, and Tiffany. She's probably called you a time or two. Consider it done. She's the backup. She prepares the slides, prepares all the materials. She's our virtual assistant, which she's awesome. So, with that being said, I'd like to my panelists to introduce themselves. They're going to tell you who they are and what they do, and we'll get started. I will be asking the questions for the first part, and then so write yours down if we don't cover it, so at the end, you'll be able to ask your questions as well. And thank you. Thanks again for being here. All right. Oh, let's start with Teresa.
I'm Teresa Walker. I'm a CPA. I'm with the firm in Richardson, Bland Garvey, PC. We're a full-service tax and accounting firm. And I'm also a certified senior advisor. And I have a niche within our practice of working with seniors and their families. I have served as a trustee on occasion, and I like to help families make sure that their loved ones' taxes are taken care of, and also assist when a loved one passes away and making sure everything gets done properly.
My name's Isaac Shutt. I'm an estate planning and probate attorney. Our office is also in Richardson, and this is all we do, estate planning and probate. So we're very deep, not very wide. You can call me about a divorce or a DWI, and I'm going to say, that sounds terrible. I have nothing to do with any of that. But anything dealing with estate planning or probate, I'm your man.
Very good. And I'm not sure that all of you know me, but I am Angela McCants. I'm a broker associate with Dave Perry Miller. I'm the organizer for this season conversations. I'm the co-owner of Dallas and Freedom Locations. And with that, I would like for Attorney Shutt here to explain to us what is probate and why it exists as a process.
Okay, probate means to prove, and so you're proving the validity of something. And probate is not one thing, meaning like sometimes people use the word probate to mean validating a will in court or probating a will, and that does go through a court called probate court. Sometimes people also use the term probate to mean validating who the heirs are in the absence of a will. So it can mean either one of those things, either validating a will after somebody dies or validating who the heirs are after a person dies. The reason those processes exist is because people aren't very trustworthy. There are people, I know, right? Shocked. So there are a lot of people who would say, I'm an heir, and they're not really an heir, they're just trying to get money. And there are people who would try to, fake a will or, show some sort of forged document, or maybe they got a loved one to allegedly sign a will when that person lacked capacity. And so for that reason, there's a court process to make sure that the will really is valid, or that in the absence of will, those heirs are truly the heirs. So it's kind of an unfortunate process in a lot of ways, because the systems are designed for less than honest people. And so honest people really struggle with it. They go, why do I have to do this? Of course this is mom's will or dad's will. This is so stupid. I got to spend $2,000, $3,000 to go through this process. Or if there's no will, it could be more like $5,000 to go through the process. And these families feel very put out. Well, the laws aren't written for the good, honest folks. It's written for the ones who aren't. And the judges don't know if you're trustworthy or not. They don't know you. And so they make everybody go through this process to vet those facts and make sure everything's accurate and good to go. So that's what probate is, and that's why the process kind of stinks.
And when might it be? You want to scoot up? That light might be bothering you. It's not? Okay. There you go. When might it be avoidable?
Well, it's easily avoidable with a trust. And we love trusts. It's kind of another vehicle similar to a will. And we kind of use the analogy of a trust being like a company. It's not a company, but that's the analogy we use. So basically, an attorney like me prepares a trust document, which is almost like bylaws for a company, and then you transfer your assets into that vehicle. And so even though you die, your trust didn't. So it's kind of still going on. And then per the terms of that trust document, it says sort of who gets what and how, automatically without court involvement. hopefully. And I know Teresa knows sometimes there are some assets that didn't get put into the trust, or some things that, despite your best efforts, you couldn't have known they're going to slip through the cracks. And occasionally we have to do a quickie probate to pick up some minor assets that didn't get put into the trust during your lifetime. But the way you avoid probate is principally through having a trust. We do have clients who are maybe up there in years that have a more modest estate and really don't have a lot of assets. And so there are some specialized deeds that can be used along with beneficiary designations on their accounts. So if you've got an older parent, they don't really have anything, they got their checking, their savings account, and their home, well, we may be able to avoid probate with specialized type of deed and with using transfer on death designations on those accounts, and then there wouldn't be a need to probate mom's will in that case. So.
Awesome. Do you have an experience? Remember that car when we were trying to?
Yes, I have a lot of good stories. I have been involved in some cases where someone has set up a trust for the purposes of avoiding probate when they pass away, and then, oops, we forgot to put our brokerage account in the name of our living trust. Or one lady, bless her heart, she actually went through the mechanics of changing the beneficiary of a very nice life insurance policy into the name of her trust, but then didn't follow up to make sure that the insurance company processed that beneficiary designation. And so even though she had everything, all her I's dotted and T's crossed, at the end of the day, we had this $100,000 life insurance policy that had been left outside the trust innocently. So we had to go through probate just so that I could get access to that life insurance policy, and then that was an additional cost. Sometimes there's been smaller accounts that get left outside of the trust, and then you just have to make a decision. Do I want to pay $2,000 or $3,000 to probate to get my hands on a $3,000 bank account that didn't get, put into the trust? So those are just some examples of, you try to avoid probate, but sometimes things just don't get handled properly.
So then that 3,000 would go through probate. Okay. Let's see. And why would you want to avoid probate? Is there other reasons? Are there other reasons you want to avoid probate?
Well, let me kind of talk about what the process is like and the expenses that are involved. And because this is all I do, this is a lot like getting the behind the scenes tour. Like, you're hearing it right from the zookeeper at the zoo here. This is what it's really like. I think sometimes, the talking heads on TV or authors of books make probate seem scarier than it is. I do at least 50 probates every year. So I'm kind of like, well, it's not ideal, but it's not terribly terrible. So let me talk about what's involved when you have a will that's valid, attorney drafted, nice professional will. We file an application with the probate court, and then the court does a bunch of behind the scenes stuff, citations, public notices, all this kind of stuff, and then there will be a hearing. Whoever the executor is, who's the nominated person to deal with the estate is, that person will get to participate in that hearing, and it's literally scripted. So right before the hearing, I hand my client a script and I say, here's everything I'm going to ask you, and there are all the right answers. So get comfortable with that, and then the judges are always so impressed and complimentary that our hearings go so smoothly, but that's because we use a little script and they're very comfortable. So then after that hearing, the executor gets a document called letters testamentary. And it's a little certificate that the judge gives you that shows you have been officially appointed as the executor of the estate. That's really when the work of the executor begins. So up until that point, going through that court process, you really don't have any authority to do anything. But once you have letters testamentary, you can go get those brokerage accounts and checking accounts and everything else. You can go hire Angela to get mom's house on the market and all that good stuff. So that's really the major milestone, is getting that probate hearing and getting your letters testamentary. So I will say that that process is totally different if you don't have a good attorney drafted will. And like literally the courts put things in an easy pile and a not so easy pile. And so you want to go in the easy pile. If you're going to go the will route, you want to have an attorney do it, because what they're looking for is an attorney drafted self-proved will. And I have a feeling that most of the time the probate judge isn't even really listening to what I'm asking in those hearings, because they're so routine. I think the judge is just hearing wah, 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 wah. Okay, are we done? Okay, and then they sign the order and that's that. But if you don't have a good attorney drafted will, that's where we have real problems, because the judge is scrutinizing everything. So people who are trying to save some funds with online wills or fill in the blank, will maker, Quicken Wills, Staples, any of that kind of stuff, that is not going to play well in front of the probate judge, because there's going to be increased scrutiny and definitely increased costs. And also, if you don't have a will at all, that short, tidy process of, what could be even just a few weeks could turn into 6 months or more. And that process is called determination of heirship, like H-E-I-R, heirship. And so your major milestone is still getting to that hearing and getting an administrator appointed. They call it administrator instead of executor. But the reason that is so terrible is because, required by law, the judge will appoint an attorney ad litem. So you file your application saying, Judge, I promise these are the heirs. And then the judge is not allowed to trust you. And so the judge is required to appoint an ad litem, an attorney ad litem, who's just an attorney like me, whose job it is to go out and fact check and see if there are any unknown heirs and stuff like that. So it makes the whole process take a long time, because the process is sort of designed to doubt you, okay? So, and there's good reason for that. I mean, it happens. There was an interesting TV show. Well, I'm a probate nerd. I love what I do. I thought this show was interesting. There was a show on cable TV called The Will, and there was a Dallas case involving like a hip hop star from like the 80s. He had a platinum album and all this kind of stuff. And he died. Okay, he died around the year 2000, and he did not have a will. And there's a lot of celebrities who die without a will, which stuns me, because they have a lot of assets. And he dies without a will, and the family files in court alleging that there are a few children and a surviving wife. And so they get to their hearing, and they're asking the judge to sign a judgment that those are the heirs, and then these other children show up saying, we're children too. And so the judge orders DNA testing. And this was relatively early in the DNA testing, technology, but the judge said, we're going to order it. And so they ordered DNA testing. As it turns out, all of the children who weren't listed on the paperwork were children, and a couple of the children who were listed on the paperwork actually weren't. And so that means that the world found out publicly that the wife had been having an affair, and those actually weren't his children. So anyway, there is a reason we have these processes, and all of that's avoided by either having a will, or better yet, having a trust, so then the family doesn't have to go through any of that expense, because even in the plain Jane heirship cases, it's kind of terrible. And so we can avoid all that. We can keep that control by establishing the trust, so then that way we can kind of manage everything, minimize those expenses, and keep the family out of court.
I have a story that can attest to that. The house had been sitting there a minute. A family member was renting the house. They said they had a will before I took the listing. So they're working on getting the family out so that we can sell the house. We get the family out, and it was not pretty. Nobody was happy about them, you know, it was just a mess. We get to the closing table because we have the buyer with a great amount because they, you know, paid well over. But bottom line is, the title company looks at the will, or whoever else looked at it, I don't know, but they finally say, we get to the closing table and we do not close because of the will. It's convoluted. So then they had to go through the whole heirship thing. And you can imagine that the people in the house were part of the heirs. So it did not go well at all. So it really helps to have, you know, to make sure it's a good will. Yeah.
I was going to ask, can you, so there were kind of three scenarios you gave with the good will, a bad will, and no will. What is the timeline and cost ballpark for each of those scenarios?
Okay, goodwill, no will, and bad will. So goodwill is about $2,500. Timeline in Collin County is about 10 days, as opposed to Dallas County, which could be between 2 and 6 months. And then all your other, you know, other counties, Tarrant, Dallas, Denton, all those guys, 3 weeks, 4 weeks, something like that. So pretty straightforward in all of those. Bad will, it really depends, because you could have like a will contest situation like that where we could end up in litigation. I think the longest that I've seen, I have an active matter now that's been pending for 8 years. So there's your outer bounds, 8 years plus, if you have a bad will, because it's hard to imagine how that could be, but when you have a bad will and maybe a signature is, you know, in question, and then you have a battle of the experts and all this kind of stuff, and then also you have a lot of them are going to be challenged on the basis of a lack of mental capacity, and so we're having all these medical records and then medical experts that are coming in and saying, well, you know, based off these records, there's no way this person could have capacity. And the other way saying, don't listen to that doctor. They've got no skins on the wall. He doesn't know what he's talking about. So it can become extremely difficult. I would say on a will that's valid, but it's like an online will or something like that, maybe it doubles the average timeline on average. And then no will at all, I would say Collin County being the fastest is probably 3 or 4 weeks on average for us to do an heirship. Dallas County probably 6 months. Everybody else 3 months. Oh, and then cost. So regular old probate with a good attorney drafted will, like $2,500. And then if you have a questionable will, it really depends. Depends on what I got to do. You know, it can really be a trial, which could be $100,000 plus, or it could be, you know, basically like a normal probate with $500 or $1,000 of extra expense, getting additional witnesses and affidavits and things like that to bolster the evidence that we need. And then a determination of heirship, which is the process without a will. I would say the average is $4,000 to $5,000, but that can even really depend on the number of heirs. You know, because we have to serve everybody. And so a lot of times, you know, we've got kind of a grandma and grandpa generation who's died, but then a lot of their lineage has died, and some of that lineage has died. So then you end up serving all of these different heirs, some of whom are minors, and it just becomes a ruckus. So I would say the average is $4,000 to $5,000, but those can go off the rails as well. And that's as opposed to a basic trust that my law office would do that would avoid probate. That's like a super basic trust, no bells or whistles or things like that, but includes like a deed for the house into that trust and some other ancillary documents. We charge $1,000. So, you know, most of our clients look at us and go, well, Isaac, I'm no mathematician, but, you know, we've got a husband and a wife. We're like, so it would be husband will probate $2,500, wife probate $2,500. That's in today's dollars. Everything goes up in cost over time, but in today's dollars, let's call it $5,000 or $6,000 total. Whereas I could do a trust for $1,000, like what am I missing here? Why wouldn't everybody do this? Well, there is an answer to that question, which is, you know, with a trust, you got to pay that money now. And we have a lot of clients who are like, hey, as long as I have a good attorney drafted will, I don't really care that my family may have to pay money when I'm gone, because I'm gone. And those rascals are just inheriting, so it's all found money to them anyway. So and we don't push one way or the other. I have a trust. You know, I think it's better to have a trust, you know, but I think for some clients, they don't see that it's worth it. But those are all the options.
Awesome, okay. Is it important, do you have to hire an attorney to go through probate?
Oh, yeah. Yes, with an asterisk. You have to have a, like for what we call traditional probate, like ordinary probate. Yes, you are legally required to have an attorney. Aside from that, like if you've been through the process, you understand why. It's not really something you can get yourself through. I mean, it's a court process, it's a lawsuit. So I don't think that most people, if they've never done it, I mean, like even most attorneys don't do probate. I mean, our number one referral source is other attorneys who are like, I don't know, I don't want to know. You've got your own code, your own judges, your own everything. The asterisk I give is that you are allowed in Texas to probate a will as a muniment of title. It's kind of like a less formal version of probate, but really what it is probate without an executor being appointed. So the code allows somebody to do a probate as a muniment of title without an attorney. However, not all of the judges do. And you can kind of understand why. If you keep in mind that a typical probate judge is going to have something like 2,000 to 2,500 cases every year, they just don't have time to deal with people's nonsense. They literally do not have time. And so when they see a pro se application, they're just going to deny it and say, go get an attorney. They just don't have time.
Okay. So,
Go
no, because we want to get through
Yeah, go ahead.
basics.
Yeah, go ahead and
because we're
finish your
trying to-
basics.
Well, I got 5 more minutes, hold on. All right, so the process is, so I die, my husband has to go through probate?
Yeah,
No?
yeah, typically.
Yeah?
Yeah, that actually, I think what you're hitting on is a really, really common question that we get in our office, which is, hey Isaac, I thought we were a community property state and I was married. Doesn't that mean that everything goes into my name when my spouse dies? And the answer is no, absolutely not. It is not it's not automatic. And number 2, it's probably not the case that your spouse gets everything. So if you don't have a will under the estates code, if the deceased spouse has at least one child from outside that relationship, the vast majority of the estate goes to the children, not the surviving spouse. So Angela, in your situation, if your husband died and he had a child from outside the marriage, not only do you not get everything automatically, you probably don't get much of anything, period. Most of the estate, from his perspective, 100% of his community property goes to his children. And so that's unfortunate news that we have to deliver to a lot of widows. And it's funny, they usually don't believe us. That's how common this misconception is. We get the 80-year-old lady in here who just lost her husband, and the husband had a child from outside the marriage, and so we're like, oh, I'm sorry, man, you're gonna have to go through this determination of heirship process. It's gonna cost $4,000 or $5,000, and by the way, the presumption is that all of the estate is community, and by the way, 100% of that community goes to his children, and they literally don't believe us. And a lot of times we'll go and talk to another attorney and then come back and they go, I guess you were right. So it's terrible. So the spouse will have a Texas constitutional right to continue to reside in the house, but that creates a huge mess because here you have title is half in the name of the children, half in the name of the surviving wife, but the surviving wife gets to continue residing there. So it's this real problem of, well, the wife, while she's residing there, is supposed to continue maintaining the house and paying taxes and doing all those things, but if she doesn't, it harms the kids. So, because the county's gonna foreclose, when you don't pay taxes, they're gonna foreclose. So it's like, well, yeah, it was the wife's obligation, but if she doesn't pay it, it hurts everybody. So it's a real problem.
It hurts everybody?
Yeah, well, I mean, because what happens is the house is going to go through a foreclosure and it's going to be auctioned. So wife is going to get punted. She's going to get booted out of the house, which is not real great for her. But also the kids are getting a less value because if you list it, you're going to get overvalue. You're going to get your top buyer and all that kind of thing. When you have like a mortgage lender or tax people or whatever that foreclose on that property because the taxes haven't been held, because the mortgage hasn't been paid, whoever's selling it, all they care is that they got enough to cover the balance. They don't give a rip what's over that amount. So that's why it hurts everybody.
Or if the kids are so inclined, they get stuck paying the property taxes trying to protect their future investment and resentment at the wife that's living there without paying the taxes.
That's usually what ends up happening. They just end up paying it and taking it in the shorts to protect their inheritance.
And how can this all be avoided?
Well, like even that, a will would take care of that.
Okay.
You know?
All right. Now, audience,
I have a question. At what point during the probate process can a house be sold?
That's a great question. So our standard advice is you can talk to your agent right away. Like I have no problem with that. Go ahead, because your agent is typically going to do things like get the house ready. They're going to make recommendations about doing this and doing that to make sure everything looks good and do their pictures and all that kind of stuff. And that does take a little bit of time. So you can do that right away. In terms of letting the listing go live or really marketing it in earnest, I'm really hesitant to have the proposed executor do that until we know what the probate hearing date is going to be. So usually I'm going to know at least a few weeks before that hearing date and time is going to be. But keep in mind that executor is not officially the executor until that hearing date. So if you get a contract before you're actually the executor, you don't have the legal power to sign that contract accepting it. And things get totally messed up. What if the judge is sick the day of your hearing and you get kicked out even further? Or what if the will gets contested, which by the way, totally had that happen one time. So you could find yourself in breach of contract and that buyer is going to be able to sue for whatever damages they have because you weren't able to deliver on your promise to close. So you can go ahead and have that agent right away. Once you know your hearing date, you can let it go on the market. And then if you get a contract, usually what I'll do, if that contract is before your hearing date, you can add in the special provisions, the closing date is contingent upon successful probate hearing. And I'll give the language to the agent to fill in there. And usually your buyer has no problem with that because they really want the property and they know that you're in good faith trying. There's nothing screwy. That just may be something that's beyond that variable of the hearing date, maybe beyond your control.
so as you as an attorney can reassure that executor or whoever that they have authority before probate
So
to
before,
sign, to even sign off on it.
well, you would know.
Somebody's gotta sign
They can sign
it.
a listing agreement. Listing agreement is cool before the probate hearing. I'm fine with that. But letting it go live on MLS, I'll usually want that to be not until we know when our hearing date is scheduled.
So you will know who, that's all I'm saying, who has authority to sign.
It's who and when. Because I'm worried about the timing because, as you know, a lot of times your best offers are your first offers.
Yeah.
And if you can't accept those because you don't know when you're going to be able to close, you're not the
I had a
executor.
situation where one sister was supposed to be the executor, and then to find out she wasn't.
Mhm.
So then the other sister was like, no, I don't want to go with this buyer. So I didn't have the right person signing. They needed both to be, both
Yeah,
of them
who
should have
signs the
signed.
listed agreement before probate?
Boy, that's, again, there's, I'm giving general advice, but there is obviously a case by case,
Yeah,
Right.
got it.
right? People are humans, and people don't do the things they should do all the time. I mean, the easy answer to that question is you should be able to look at the will and see who the executor is to back up who really is the proposed executor. So that would be relatively easy to look at, but obviously your
Certain
mileage may
things.
vary.
Yeah, got it.
Have an attorney. I mean, I know that sounds basic, but in your particular case, you would ask me, hey Isaac, Angela would like to have the house go on the market. Please advise. Okay, let me look at it.
Okay, I think that makes good sense, right?
All right, got your question. When should you have a will, trust and how?
When should you have a trust? If in your personal metrics you feel it's worth it to have a trust, then by all means get one. Remember earlier I said I think a trust is always better. Okay, I can say that almost unequivocally. I've handled now over 1,200 will probate cases myself. So I can tell you that having a trust is better.
I got that part. I'm just talking about in terms of when, because you mentioned that it's before you pass on. And I know when you get a trust, you put your car in the house, assets and all that stuff. So it's got to be managed almost like a business, am I correct?
Not really. So typically the way, like the type of trust that we're talking about is a revocable living trust that's really just designed to do the same thing as a will would do, just not. And most of those are like the old, you remember Ron Popeil? You said it and you forget it. Most of those are pretty much set and forget because you as the client, you're the trustee. And a lot of times, like Teresa was saying, on your life insurance policies or whatever, you're not actually changing the ownership of those accounts, you're using your beneficiary designations. So you've got this trust document that I've prepared. The trust exists, we funded it with $10, and so it's sitting in a binder, and you don't think about it. You're not paying anybody, there's no, attorney fees or trust maintenance, you don't really need a professional trustee, like it's just not doing anything.
Okay, so simply it's just a document for the most part.
No, it is a trust relationship. He asked, so the trust is a document, and the trust isn't a document, it's a legal fiction that's managed by a document, but with your typical revocable living trust, nothing is happening while you're alive. It's just doing nothing.
Second question. For you, Teresa, in terms of taxes on a trust, how does that help in terms of tax obligation to the heirs? Does that help much?
That's a big question.
Yeah. Well, typically in a revocable living trust, the trust doesn't really come into play for tax purposes until that person passes away. And so then the trust becomes irrevocable and then assets are distributed. There might be some interim period where there's income that the trust recognizes that it pays tax on. There may be reasons that the income stays in the trust and it pays tax on it. It's usually more advantageous for that to be passed down to the beneficiaries because individual tax rates are less. Let me just say this. They don't get high as fast as they do on a trust. Trust tax rates get high really fast. The chart is different than individuals. So, but sometimes, that's a big question. Sometimes there's reasons for the trust to pay the tax. Maybe there's the beneficiaries of a special needs trust and it's not going to pay. I mean, there's just a variety of reasons, but the trust itself doesn't change a tax scenario until someone passes away. Is that
Yeah, that's
helpful? Yeah.
Hey, mine is sort of a building question for the panelists. How if you have an ILET or a second to die policy, should it go into a trust? Is that better, even though it's clear in the will and it's clear on the beneficiary line who the beneficiaries are? And if it does go into the trust, once either the first or the second partner dies, what's the advantage of having those policies in the trust for tax purposes?
Okay, so for people who don't know, he mentioned something called an ILET, which stands for Irrevocable Life Insurance Trust. And, you know, when Teresa was answering the last question, I think it's important to know that there are a lot of different kinds of trusts. The type of trust that I've been referring to so far is for a probate avoidance revocable living trust. But there are millions of different kinds of trusts that have all kinds of special purposes. One of them being when we have a special need beneficiary. Sometimes we have a beneficiary with a substance abuse problem or myriad of problems, and that's one of the really great things that we can do with the trust is we can customize distributions. We love that. With the will, it's very regimented. It says what it needs to say. You don't get a lot of creativity. You don't want the probate judge to go, oh no, this will is creative. Whereas with the trust, you know, I've done a trust that was designed to own a house for a cat to live in. So just to give you some perspective for what we can do with the trust, there are a million different variations. So even within the ILETs, there are different kinds of ILETs that have different terms to that trust, and whether or not it has a second to die policy or just a regular plain Jane life insurance policy is going to make a huge impact even on your question on whether or not it makes sense to keep it in a trust. When ILETs were really, really popular, like late 90s through like 2004-ish, it was when we didn't have estate tax portability among spouses, and we really need to be careful about fully utilizing both spouses' estate tax exemption. And I don't want to step on Teresa's toes because I know enough about taxes to tell you to go talk to Teresa, who, by the way, Teresa and her team at Bland Garvey are awesome. I'm not just saying that, they really are very, very good and thought of as top-notch and all of that stuff. And they do have special expertise on exactly your question, especially Teresa dealing with, especially taxes dealing with trusts and things like that. It's very important that you ask these questions early on because it has ramifications way down the line. So on the planning side now, we need to make sure things are done carefully so that it makes sense years and years down the line. I know that was a jog, and I'm giving you a long answer to a short question, but that is because the short answer to your question is, it depends, which is the lawyer's answer for everything. I would say from a tax perspective in today's laws, there's probably not a really great reason to have an ILET when you're wanting to go to the spouse owned by that ILET. But a lot of people still do life insurance in the marital context with an ILET, like in that blended family scenario we talked about before, where they want to make sure that my kids get something. I don't necessarily put all the faith in the world that my spouse will pay all of these proceeds, like whatever's left over after my usage, to my kids. So we'll use a trust instead, where that trust owns the policy, it's the beneficiary of the policy, and the wife has utilization while she's alive, and then whatever is left over upon her death would go to the husband's children. Does that make sense? Mm-hmm. So there could be reasons for a life insurance trust just outside the tax scenario. And then also, even like for our, wealthier clients, where we know they have a taxable estate even without looking at a life insurance payout, ILETs are awesome for kind of their original purpose, which was being able to fund the premiums over time to remove the payout from your individual taxable estate on death. So that would still apply no matter what. And in fact, after President Biden was elected, we had a bunch of clients that were interested in ILETs again because his proposed tax plan was to bring down the estate tax exemption a lot, meaning you couldn't give away as much tax-free. So suddenly that $1 million policy that didn't seem like it was that big of a deal is now a huge deal because these North Dallas homes that were not worth that much, now they're worth over $1 million. And you got a modest savings, you got $1 million policy, you might feel blue collar, but now that's a taxable estate. And so we need to utilize some sort of trust to take that payout from the life insurance out of your trust. Or, I'm sorry, out of your estate.
Same thing with the second to die?
Well, pretty much. I mean, the same considerations are still there, just maybe less so. Did I botch that too bad?
No, that was great.
Okay.
And I promised him I would let him leave at 11. Could you tell us what an hour consultation fee usually is?
Yeah, so we keep things really, really simple at our office. We charge $150. So basically that'll get you a meet with me or one of my associate attorneys who are awesome. We all do the same thing. Our whole MO at our office is less is more. We will not overcomplicate anything. I think a lot of attorneys are in danger of making things seem more complicated than they really are to justify themselves. We don't do that. We'll get you a right-sized solution and then do a review and signing meeting, and usually you're done with us that way. So.
Wow. Teresa's able to stay. Isaac has to rush. Can we give you
Oh, thank you all. Thank you all so much.
thank you
All right, you're welcome.
for all
Thank
that
you.
great information.
Thank
and
you.
we appreciate
All right,
it.
we'll see you next time.
All right, thank you.
All right, great to see you too.
Thank you.
All right, bye everyone.
All right.
See you.
Take a buntini, a couple. All right, you all, we would love your feedback. And the survey is nothing very personal. In fact, we're not even asking you for your name on it. We just need as much feedback as possible. So please, even if you filled out one before, fill out this one too. And if you have any other questions for Teresa, she's going to hang around for a little
I was
bit.
going to just add one
Yeah.
little thing, thinking about some of my experiences that I've had. Let's say someone passes away and they are behind on their taxes. And now we've got kids that are scrambling, they don't know where the information is, they don't know how to get it. It can be a real challenge to get information from the IRS unless you have, well, on a good day, it's hard to get information from the IRS. But I generally can call the IRS on behalf of a client with a power of attorney. It can be a challenge to have a power of attorney for someone who's passed away unless there's a named executor or administrator of the estate. So I've had situations where we've just kind of had to do our best because we couldn't get the information. But then I've had clients that their daughter or son was the executor, so they give me that, and then I'm able to use that to get power of attorney and get information from the IRS. Because it could be 3 years down the road before the IRS realizes, oh, John Doe owes us $10,000. And nobody knew, and the estate's already been distributed out, and so now who's going to pay? So I just wanted to mention that's another, kind of a important piece of that probate process, getting that executor named. It also opens the door to get information from the IRS.
And in terms of all our information, what's the best way to keep all of that? And who should we, if you're not married, how do you save it? How do you know who to have access to it?
If you're not married, if you have a trust, then your trustee should always have access to that information that you have. And I can't stress the importance of logins for people that need to be able to get access to your accounts and things like that. I also have back there, if there's a few left, there's sort of a booklet you can use to put your accounts and information, and then you can, yeah, he's got one right there, yeah.
Yeah.
You can make sure someone knows where that lives, so that if something happens to you, they know where to go get that information.
Hi. Hi. My question is there a particular way, because I heard a story about a week ago in our shop, and is there a way, in case you've forgotten a policy or something that you have open, maybe you work somewhere, 15 years, and, you worked another place another 15 or 20 years, and you may, someone else, your beneficiary, you've forgotten all about that. Is there a way that we can either go in with our socials or go in with something to retrieve or find any missing policies or anything?
So
that we
the
forgot about?
scenario is someone's passed away, and you want to make sure you haven't left any stones unturned.
Right.
So, I mean, you could always reach out to those former employers and see if
Okay.
they happen to have life insurance that was part of their retirement package
Okay.
or something like that. I mean,
Okay.
my guess is that every company probably has different ideas about how much they want to tell and not tell, but I would start there.
Okay, okay.
All right, well, again, next week, next month, they're like weeks to me, they go so fast. I think we're gonna talk about liquidation. Don't hold me to it, but I will send you make sure we have your emails. We will send you notes. Please share. This is, we're just trying to prevent, my dad used to always say, prevention is better than a cure. So you gotta know what you don't know. Thank you all. Thank you. Great time.
And a reminder, I will collect these, so make sure you see them before you leave. And also, can we wish Angela a happy birthday?
Now this was a surprise. Happy birthday.
Well, y'all are part of my birthday.
And I was telling them, the other day, I went to Corner Bakery and the guy asked me if I was a senior. I was like, oh.
But they do start calling us seniors at 50.
Yeah, see, Angela.
So
Okay,
Let's
all
do
right,
this time.
that's a good
Just
thing.
go.
That's what I told
Appreciate
her.
that.
It's a blessing.
Yes.
All
Use
right.
the discount.
Yeah.
You
Thank
always
you.
forget to set the